or two more minutes, 1 or 2 more minutes just for some other participants to join in. For everyone's information, we have 60 confirmed participants for today's session, and we have about 19 now. So let's just give them another 2 or 3 minutes just to log in, and then we will all start. And thank you for your patience. Okay, thank you, colleagues. We should start. I think we've got a number of people here, and some of them might join as we go through. So I would like to welcome you all to this fourth Pacific webinar organized by Secretariat of the Pacific Regional Environment Program. And I would also like to thank you for all taking your time to be in today's session. Before we proceed, I just wanted to kindly ask if you can all keep your microphones mute, and when you're speaking, please, you can switch it on. Thank you. So today's webinar is on prior informed consent and mutually agreed terms, which is under the Nagoya Protocol. And our theme today is negotiating a contract, inclusive decision-making process in access and benefit sharing, and biotrade, breaking barriers in implementing the Nagoya Protocol. I would like to thank our partners, ABS Capacity Development Initiative, and our funding agency, Global Environment Facility and the UN Environment. We are collaborating this event today with University of New South Wales, University of Technology, Sydney, our local partner in Samoa, Scientific Research Organization of Samoa, our Pacific Island governments and NGO partners. Without taking much of your time, we will straight go into today's program. We have 5 speakers today. Each of them will be speaking with very short interventions of about 5 to 8 minutes. And then after that, we will have comments and questions from the moderator. And following that, I will open the floor to ask all our participants if they would like to ask for questions or any comments, and we will lead into discussions after that. So our first speaker today, I would like to very briefly introduce you our first speaker, Professor Daniel Robinson, who has a background in human geography, environmental science, and environmental law. Professor Robinson research focuses on regulation of nature and knowledge. His papers and books cover themes including biopiracy, access and benefit sharing relating to biological resources, appropriation and regulation of indigenous knowledge, indigenous customary laws and biocultural protocols, ethical biotrade, political ecology, environmental policy and management. He also has interest in environmental and social implications of multilateral, regional, and bilateral trade rules and negotiations, and has several papers and chapters on the negotiation politics of these forums. Professor Robinson has acted as a researcher and policy advisor on projects for International Center for Trade and Sustainable Development, with their joint project with UNTAD and United Nations Development Program and the Global Environment Facility, the German Development Implementation Agency, OZAID, and Department of Environment, Natural Justice, and Union for Ethical Biotrade, and of course the Pacific Islands Forum Secretariat. Professor Robinson is an academic and co-lead of the Pacific at the UNSW, University of New South Wales Institute for Global Development, and he's also currently the Pacific Regional Manager of Access and Benefit Sharing Capacity Development Initiative. He's also the chief investigator with Dr. Margaret Raven on the 5-year Australian Research Council Discovery Project on Indigenous knowledge, futures, protecting and promoting Indigenous knowledge. He has been with the Secretariat of the Pacific Regional Program as a collaborator and our partner, and we have made many joint national and regional capacity building sessions over the years. With those words, I'd like to welcome Professor Daniel Robinson.
Thank you, Rahul, for that very long introduction. I appreciate it, and it's been great to work with SPREP over the years. So I really I really appreciate the SPREP team organising this webinar for the region. So yeah, as Rahul explained, I'm with the Access and Benefit Sharing Capacity Development Initiative, and I know many of the people I can see in the room, the virtual room on Zoom. Today I wanted to talk about a bit about the intersection really between biotrade and access and benefit sharing, with a few examples from the Pacific. And I think that will get into some of the key issues we see with prior informed consent and negotiating mutually agreed terms. First, I wanted to say that I'm really pleased to see, I think now 9 or 10 Pacific countries have ratified and adopted the Nagoya Protocol, which is really great to see. And many of the countries in the Pacific Islands have established permit systems as part of their national prior informed consent process for access and benefit sharing. And then a lot of them also have a local prior informed consent process as well. So often researchers have to come and get the permit first if they want to come to your country to do research, but then also permission from local communities. I have received lots of questions about this, a particular area from the Pacific countries. So when we've done the work, when we used to be able to travel in the Pacific, or either online or by email from some of you, about the definition of research and development as against what we sometimes call biotrade or commodity trade in a biological resource. And so really we're talking about where there's a new and innovative aspect of the research that's being done, and the people are usually from university or from a company that wants to do the research on it. There's usually some sort of intensive study or laboratory study in relation to the biological resource we're talking about. And it can be a range of different things. It might be marine genetic resources, sometimes it's sponges or microbes or coral reef. And then there's a lot of plants that have been collected by researchers throughout the region as well. Often medicinal plants that we know about, and I'll talk a bit more about plants particularly. But there's this question: where is the line between the use, the use and the sale and the commercial trade of the biological resource and research and development? The access and benefit sharing applies to utilization of genetic resources, including their derivatives and associated traditional knowledge under the Nagoya Protocol. So that's quite a wide scope, but it has to, utilization part of it means research and development. So where there is some sort of research on it, that's when we're talking about access and benefit sharing. And obviously, there is a lot of trade in some of these biological resources we're talking about. So things like kava, seafood, fish species, marine species, coconuts, all sorts of things are traded in the Pacific. A lot of plants and crops and things. But when the people accessing those resources are doing research and development with the aim to commercialize those, that's when we're talking about access and benefit sharing. So this can mean new uses of those particular products. It might mean new derivatives. It can mean new formulas for things like cosmetics or recipes for a food product, new mixtures for a beverage like a food and drink, skincare, medicines, drugs, pharmaceuticals, those sorts of things as well. Sometimes it's for industrial enzymes and other things that are used in industrial processes, and it can be fibers as well. When people are saying that they're going to do those sorts of research activities, that's when we're talking about access and benefit sharing. And if people are just trading it, like it might be inter-island trading or trading even to Australia, New Zealand, America, if it's just trading without any research, then that's not in the scope of access and benefit sharing. But we do want to know what those companies are doing, if possible, if those companies are planning to do research, basically. So even when there's academic research, there should be a permit. So quite often we've had countries contact us and say, look, we've got some academics coming to do this research. Does this sound just academic or is it commercial? And that's a question worth asking. Is it what's the intent of the research? Is it about the ecology of an ecosystem? Or is it an academic study for writing some journal papers? Is it taxonomic, so identifying species? Or is it about commercializing, developing new products? And that's where, you know, we were doing research in all types of research, really, they should be getting a permit. And if it's academic research, they should be maybe sharing non-monetary benefits. So we could have non-monetary benefits where it's university researchers, for example, or they might pay an access fee, a smaller fee than, say, a company would for commercial-oriented research. But yeah, there's certainly lots of examples where biotrade may involve research and development, and I want to give some examples of these from the Pacific. So the first one is kava, one that we should all be quite familiar with, I think, in the Pacific. I've had many wonderful kava sessions in Fiji and Vanuatu, and it's obviously something that's popular and has been traded and exported within the region, but also outside of the region. So I occasionally bring some kava back to Australia. I'm allowed to bring a little bit under our quarantine laws. And obviously that's okay, and that's part of what we call biotrade. So it's a biological commodity, and that's what's just being used and traded to another country. But where it gets, where we're interested in the access and benefit sharing side of things is where the research is being done by those other companies. If you've got a company buying it in bulk, that's where we might sort of start asking questions, buying tons of kava powder, for example. So there are some examples of this, and I noticed in Vanuatu we were looking at some kava traders. We went to their businesses, and for example, there's one called Gaia Herbs, a US company, and they do herbal remedies. But I noticed they had pills, tablets that they mix kava with turmeric, and it was supposed to be a relaxant. And they'd actually filed a patent relating to the combination of things that they were putting in a tablet as a herbal remedy. Now that's the sort of situation that we think really that company should be getting, setting up an access and benefit sharing agreement with Vanuatu if that's where they're getting the kava from. So this is where we get it crossing the line into relevant to access and benefit sharing. And then we often call those access and benefit sharing value chains if they've got an agreement. So we want to encourage those businesses to set up an agreement. So we know with kava, for example, there are 200 patents on kava now around the world. So obviously researchers are doing quite a bit of research on kava, and they might only need a small quantity. Often companies will buy significant quantities if they're doing a lot of research. But that's clearly one good example that people might be quite familiar with. Obviously, one thing that governments could do, and we've kind of done this with some governments, the Access and Benefit Sharing Initiative and SPREP, we've spoken to some of the companies involved on behalf of the Pacific country, and just sort of said to them, look, you know, we have this system under Nagoya Protocol. There are rules within the country. If you want to do research on these products, you should be getting a permit, and you should be sharing benefits with the providers. And it depends on your national system who those providers are. So it could be the local community. Often in the Pacific, it usually is the local community is considered the provider because they have customary rights over those resources. The company who trades in it might also be involved because they might be buying it from multiple islands. So that might be a mechanism for doing the benefit sharing. So they might be part of the agreement. And sometimes the government might also be part of the agreement. Depends on your laws in your country. So it is worth asking those companies that are trading significant quantities overseas if they know if there are researchers, and then encouraging the companies involved, the traders, to set up a benefit sharing agreement. And one thing that's worth noting is that it's possible to do it a bit like a fair trade agreement. And we've seen that in a few cases around the world, particularly for things like foods and cosmetics. That's one where you can add, where they buy quantities, you add a surplus on top of the payment price, an additional cost, and that's the benefit sharing cost. So that's one way it can work. Another is Tamanu, and I don't want to take too much more time. Another is Tamanu, and that's Calophyllum inophyllum. It's also known as fatau or dillo nut. There are 137 patents relating to that. It's mostly found in coastal zones in the Pacific and Southeast Asia. So it crosses outside the Pacific into Southeast Asia and parts of Australia as well. So people might be accessing it from multiple countries, and there probably is some Southeast Asian traditional knowledge relating to it. But we know there's a lot of Pacific traditional knowledge. In Fiji, it's called dillo nut, and it's used for different purposes. Samoa call it fatau. In Vanuatu, it's tamanu. So that's another one where companies could share benefits when they're buying it. Could be like a fair trade type agreement. Another one is Canarium indicum, and that's nangai, and that's also known as garlic or gnarly nut. And there are not many patents on that. There are about 9 applications. And so again, this is one where there could be additional payments made and benefit sharing agreements set up. And we know there are sort of cosmetic, particularly skincare, relating to both of those, to tamanu and nangai or gnarly nut. And so last, I just wanted to make a couple of points in terms of making those agreements. It could be for different things. For food and cosmetics, we might be talking about short timelines, so things that can be researched and then on the market very quickly. In those cases, you might want upfront benefits in the short term. For pharmaceuticals, it can take a much longer to develop those drugs based on those plants or based on traditional medicines. So you might want milestones and royalty payments that go for much longer periods of time as that drug gets developed. And then you also need to think about a range of other potential benefits. It could be things like data sharing. You need to think about the duration of the agreement. So whether it lasts in perpetuity or it lasts for 50 years, you probably want quite long agreements so that the benefit sharing is sustained. You need to think about patents and whether you want to allow patents. So some benefit sharing agreements say, no, you're not allowed to. You can use trademarks or other things, whether you're allowed to do that. Then exclusivity is another one. So whether you want a few companies doing research on companies so it's easier to deal with. And then it's good to have dispute settlement and resolution built into the access and benefit sharing agreement. So I hope that helps. I wanted to give a few examples from tangible cases from the Pacific. And I think I'd better stop there because I've probably gone slightly over time. Thank you, Rahul.
Thanks, Professor Daniel. So thank you very much. You've highlighted some important points, especially to do with how communities who are trading their natural resources and biological products to different countries under trade agreements, whether that could come under the envelope of ABS agreements. We'll talk about that a lot more, but that takes me to Dr. Our next speaker, Dr. Ivana Wright. She's a senior lecturer at the Faculty of Law, University of Technology in Sydney. She has a PhD from University of Technology Sydney as well, and her thesis examined the legal regimes for protection of traditional knowledge in India and Peru and identified lessons for Australia arising out of the experience. In her experience, her research expertise is focused on protection of indigenous traditional knowledge situated at the intersection between biodiversity conservation, access and benefit sharing regimes, and intellectual property rights. Her work identifies reforms that can empower indigenous and local communities to make decisions regarding the use and exploitation of their traditional knowledge. Some of the highlights of her work on ABS are one of her books, Protecting Traditional Knowledge, Lessons from Global Case Studies, was published by Edward Elgar in 2020. And prior to joining the University of Technology Sydney as a lecturer, she was a research fellow at the Australian Research Council on Linkage Project, Garuwanga, forming a competent authority to protect Indigenous knowledge. As part of this project, our research team worked with Aboriginal communities in Western Australia and New South Wales to develop an understanding of community needs and expectations in relation to the governance of Indigenous knowledge and the role of competent authority under Nagoya Protocol. Dr. Ivana Wright was also part of the SPREP ABS regional capacity building workshops in Nadi held in Fiji in 2018. is to provide us assistance and expertise when needed. We'd like to welcome Dr. Ivana Wright.
Thank you, Rahul, and thank you, Daniel, for your interventions. I think mine will follow on quite nicely. So I'd like to talk about negotiating access and benefit sharing arrangements, in particular benefit sharing arrangements, and some of the issues or barriers that communities or negotiating teams might come across. So following on from Daniel's discussion around benefits and the types of benefits that you might want to look at depending on the engagement, whether or not it's, say, cosmetics or skincare, which might be a shorter term engagement, or pharmaceuticals that may be a longer term research and development and engagement process. Negotiating these types of arrangements can be complex. The commercial applications and the outcomes of research and development is often unknown, and this can present difficulties in establishing what might be considered appropriate benefit sharing for a particular case. And this is a complication that arises outside of access and benefit sharing in relation to biological resources and traditional knowledge. It's a common area of negotiation in all types of research and development agreements, but it becomes more complicated in the case of biological resources and traditional knowledge, typically because of a power imbalance between the negotiating parties or the interests. Now, as Daniel mentioned, we often see proposals around royalties when we're looking at research and development for pharmaceutical products. And these will require parties to provide access to genetic resources and traditional knowledge in return for a certain percentage in royalties. And this can be expressed as a percentage of profit from a product developed based on such resources, and how that's defined can be quite complicated. It can be defined as a percentage based on after-tax profit, so what the company makes after they take out all of their costs, after all of their taxes that they've paid the government, whatever is left, then the royalty is calculated based on that. As a percentage of that. Other times the clause can be drafted so that it's a percentage of income in relation to that product before taxes, so that it ends up being a higher percentage for the community or the government who's entering into that arrangement. But the question is, what happens, what benefit will the providing party derive from the arrangement when the product doesn't reach commercialisation, or where there's a delay in commercialisation through no fault of the access provider? What happens if the community agrees that the benefits will be royalties and the product is never commercialised? So the community can find that they've provided access to resources and knowledge without receiving anything in return if they put all of their benefits into a royalties arrangement. So it's important to consider a range of options in order to secure benefits for knowledge holders and communities. So while royalties can be a very useful form of benefit sharing, parties should think about using other forms of benefit sharing, such as upfront payments in return for access, as well as other non-monetary benefits. And so we've seen with cases such as the Mamala case in Samoa, and Professor Robinson's written a lot about this case, that there were a number of arrangements. So there were upfront payments, there were milestone payments, royalties based on revenue generated after cost, as well as non-monetary benefits such as infrastructure development. And so that means that when commercialisation, or if commercialisation is delayed, or if it doesn't eventuate, the community has still derived benefit, and the risk of not receiving benefits has been balanced by other upfront payments and non-monetary benefits. And related to this is another option that is commonly presented by industry as a benefit sharing option is joint ownership of patents. Now, under the Nagoya Protocol, joint ownership of patents is seen as both a form of monetary and non-monetary benefits. And it's quite often presented as this is a good way of recognising the communities or the country's rights in the resource and in the knowledge that might lead to a patented invention. And that is a good thing, to recognise the rights of communities in knowledge, in resources. And we've seen that, for example, in Australia, there's a number of arrangements, one of which the Jamadanga Buru community in Western Australia has entered into an arrangement with Griffith University for joint ownership of patents in relation to a novel form of analgesic that's derived from a local plant and local knowledge. And this is a great idea if the patent is then commercialised and income is derived from that patent. Then there's the potential for income for that community. But the joint ownership of IP can pose serious risks for the parties involved, and they should be approached with caution. So it can result in uncertainty and conflict in the absence of a well-drafted agreement surrounding that joint ownership of IP. And this is because the laws around joint ownership of patents varies from country to country. So the rights that you might think you have in one country if you're a joint owner of a patent are very different in other countries. So there's a big difference between Europe, Australia, the US, and other countries. And so you might find that one party has the right to exploit a patent, and you can't stop them from exploiting that patent. And therefore you might not be able to derive any benefits from the patent or from what that other party is doing. If they're going off and commercialising it on their own, there'll be no income to you. So you want to make sure that your agreement has very clear terms around who can do what with the intellectual property, what terms can they be exploited on, how should the income be shared, can you license or assign your rights in the patent? Because you want to be able to control the activities of the other party. If they can go off and commercialise without accounting to you, then having your own rights in the patent don't necessarily mean you will get any benefits. Or you might find that the other party can block you from using the IP in the patent in the way that you might want to. So the other risk that might come out, I'll wrap up because I think I might be running out of time. The other risk in relation to patents and joint ownership of patents where parties agree to have patents is that if the commercialisation process doesn't go anywhere for whatever reason, there's a lot of costs involved with clinical trials or financial events like the global financial crisis in 2008, that impacted the arrangement with Jamadanga Buru community because people weren't investing. If for whatever reason commercialisation doesn't go ahead, having a patent can mean or will mean that your knowledge will go into the public domain once the patent term expires. Patent protection is only 20 years. And so it does mean, unfortunately, that where commercialisation isn't successful, the IP will go into the public domain for anyone to use. And just finally, in terms of negotiating the agreements, negotiating the agreement is not the end. So you don't just finalise your agreement and put it in a drawer. It's a living and breathing relationship that maps out obligations and responsibilities. And so it's important that it becomes a continuing relationship with communication between the parties to report, to share information, to identify barriers, and to adapt and adjust where necessary. And having those milestones built in is a really important part of that. So I think I'll wrap up there, Rahul, and my timer went off. Okay, thanks.
Thank you, Dr. Ivana. I think you've raised some very important issues about negotiation, and especially when we are dealing with patenting. And we'll talk about that a lot in detail when we do question and answer sessions. Maybe there's some clarifications from the floor. Also to do with how do we decide the valuation of intangible assets, and how do we arrive at, as you mentioned, about the set formula and whether it fits for everyone or not in every country, every situation. So we'll talk about that when we go to question and answer sessions. Now I have on my list is Ms. Ofa Kaisami. She is the manager of the Pacific Climate Change Center at the Secretariat of the Pacific Regional Environment Program in Samoa. And she has been in environmental law field for some time. She was the environmental law advisor for government and regional organizations for about 10 years. She has represented advice on legal issues such as illegal access to genetic resources and traditional knowledge, environmental rights, law of the sea and international resources law, water law, climate change law, and management of land subject to customary title and other public land. She has experiences in areas of climate change, sustainability and renewable energies, sustainable land management, sustainable agriculture, farming, integrated coastal management, and climate change mitigation and adaptation. In the recent past, she has been the legal advisor for the Global Environment Facility funded SPREP regional project on access and benefit sharing. And she was also the head of legal division of Ministry of Meteorology, Energy, Information, Disaster Management, Environment, Climate Change and Communications, MEDAC in Tonga. She has a Master's of Law in Environmental Law from Australian National University and a Bachelor of Laws from University of the South Pacific, a Diploma of Oceans Law and Policy from Aegean Institute for Ocean Law and Policy in Rhodes, Greece. Ofa, you have the floor.
Thank you very much, Rahul, for that introduction. Very detailed, but thank you. And thank you for the opportunity to speak on this webinar for the Pacific. I think firstly, I would like to acknowledge our governments, our participants from our countries. Thank you so much for tuning in today. But also I would like to acknowledge our partners, UNDP, the APS Initiative, University of New South Wales, I have here SROS, and all the helping hands of the ABS project. Let me begin by congratulating the countries who have ratified the Nagoya Protocol. You know, this is the 4th year of the project, and we have about 11 countries from the Pacific ratifying the Nagoya Protocol. And I'm mentioning that because what I'm going to speak on is that I think it is time for us to put some compliance measures in place for our countries. As you are aware, once we become a party to any of the convention, we need to domesticate the conventions itself into our national laws, into our policies, but also into our guidelines. Today, I will be talking about the legal issues with regards to the compliance measures and implications of the Nagoya Protocol. But I would also like to touch on the challenges and difficulties in implementing the protocol in our countries. There are few articles in the Nagoya Protocol that requires countries to put some compliance measures in place, and that's Article 14, Article 15, Article 16, 17, 18, and 30. For Article 14, it's a requirement that each party shall make available access and benefit sharing clearinghouse and the information that is required. I'm happy to say that we have one country that have already put up their interim national report, and congratulations to Samoa. So only Samoa in the Pacific have complied with Article 14 in the fact that they have already deposited their national implementation report onto the ABS clearinghouse. So I'm calling on the countries to please make an effort to have that compliance measure in place by putting together your national report and putting it up on the clearinghouse information. Article 15 is a compliance with domestic legislation and regulatory requirements. And there are a few countries from the Pacific that have done so. So thank you to, and that's Palau, Samoa, Vanuatu, Fiji, and Kiribati. FSM has got a policy that needs to be reviewed. And also the Republic of Marshall Islands have got a draft policy which was drafted through the project. I'm happy to say that in the effort of this project and in collaboration with the ABS initiative, we managed to put through the first standalone ABS legislation for the Pacific, which is the Republic of Palau in 2018. So the team is currently pushing for the regulations to go through Parliament to be enacted. So thank you, team, for that work. In terms of Article 16, compliance with domestic legislation, regulatory requirements in the context of traditional knowledge associated with genetic resources, I'm happy to say there are a few countries from the Pacific that have enacted traditional knowledge laws, and that is Cook Islands, Palau, Samoa, Vanuatu, and Fiji. I think Fiji's one is still in draft. It's just a matter of looking into it and putting it through for endorsement. So that's Article 16 on compliance. On Article 17, monitoring the utilization of genetic resources, where you have to establish checkpoints. There is one country, I think, that is ahead of other countries, but doesn't mean that other countries cannot do it. One is Samoa, the only country in the Pacific that have designated a checkpoint through the national law is Samoa. On Article 30, which is, on Article 18, which is compliance with mutually agreed terms, there are 3 countries from the Pacific. Participants can also correct me, but this is the data that we've collected through the ABS project. Compliance with mutually agreed terms, there is Palau, Vanuatu, and Fiji who have established free prior informed consent as part of their laws and policies. On Article 30, procedures and mechanisms to promote compliance with the protocol, the only country that have complied with Article 30 from the Pacific is the Republic of Palau through the ABS laws, which was drafted in 2018. Having said that, I would like to also touch on the general considerations and challenges and difficulties in implementing the protocol in the Pacific. And I think this is very important for our partners, but also the ABS project to also have a look into the challenges and difficulties in implementing the protocol and probably create capacity building and training around these areas. One is that most of the Pacific countries highlighted the fact that the Nagoya Protocol was a new instrument, especially for our countries that had just recently ratified it. And that they were still in the process of establishing access and benefit sharing measures and appropriate institutional arrangements. Many Pacific countries also highlighted the cross-cutting nature of the protocol, which is relevant to many sectors, and the need to involve many actors, and as an important challenge for the adoption of measures and progress towards implementation. And this is a challenge that is common in the countries with regards to implementing the Nagoya Protocol, is that there are many actors that need and sectors that needs to be involved in the implementation. Because a number of parties, they recognize that this created challenges in the implementation. First of the challenge here is that in ensuring the participation in ABS process, especially the local communities, they need to know where they are involved in the process, in the ABS process. And although the number of capacity building and training initiatives that are currently supporting the ratification and implementation of the Nagoya Protocol, the many Pacific countries reported lacking the necessary capacity and financial resources to make the protocol operational. So capacity building and development support continue to be an essential part in order to make progress in the implementation of the protocol in the countries. The lack of human resources working on ABS and the Nagoya Protocol also seems to be a common challenge in the Pacific because all our countries have indicated having very limited human resources working on Nagoya Protocol, but also there are staff who has already have a dedicated work stream that are required to also look after the matters on ABS. And 5 is that many highlighted the need for capacity building, ongoing capacity building and raising awareness of the protocol that involves all the sectors. I think with that, Rahul, that's my contribution today to the meeting. But as I mentioned earlier, the countries, it doesn't mean that we ratify the protocol, that we become, that we don't have to move forward from the ratification. We need to put some compliance measures in place, and the team here at SPREP have contributed largely to implementation of the Nagoya Protocol in the countries of the Pacific. So I urge everyone to be in touch with the team so you can get advice moving forward with the implementation of your protocol at the national level. Thank you very much.
Thank you, Ofa. I think you have mentioned some of the very critical issues that we have in the Pacific in terms of compliance measures, and also thank you for highlighting the success stories of the Pacific in terms of ratification. We have 11 countries of the 14 that we are working in that have ratified the Nagoya Protocol, the latest being Kiribati. So thank you, the Pacific Island countries. And also, very briefly, you've mentioned about some countries that are taking lead measures in implementing the Nagoya Protocol. For example, Palau coming up with a first of its kind standalone access and benefit sharing law. We have TK-related laws and legislations and policies. Countries such as Marshall Islands and Tuvalu are developing their national ABS policies. And in the long term, they would probably look or explore options of developing a legislative framework. So thank you so much for reflecting that. I will now go on to our next speaker for today. And she is Ms. Margaret Tabukawai. She is from Fiji and considers herself as the defender of justice for her people and an advocate of traditional knowledge. Her qualifications: she has Masters in Communication for Conservation from University of El Paso in Texas. Her experience as 12 years in civil service with Ministry of Fisheries, and recently she was also the FLEMA coordinator. FLEMA is Fiji Locally Managed Marine Areas. She has been a coordinator for almost 5 years, and a highlight of the career was that she was, as part of FLEMA, convening with ministries partners, Ministry of Environment and Water Management and UNDP in the first year of ABS National Community Consultations in 2018. She has also been involved with integrating FPIC, the Free Prior Informed Consent process, into the work that she's been doing with communities, as well as transparency across knowing and understanding the rights, but also the responsibilities when it comes to natural resource management. I'd like to welcome Ms. Margaret Tabukawai.
Everyone, thank you, Rahul, for that introduction this afternoon. I must apologize. I'm on this webinar from my residence, as we are currently restricted to working from home in Fiji at the moment. But I'd like to take this time to thank SPREP, all of the partners and donors and all of the esteemed speakers here for this panel in allowing us this space to share our experiences and also share a bit of the knowledge that we have around the space of ABS. I'd also this afternoon like to acknowledge as I sit here to just mention that I'm sharing the experiences and voices from those who have paved the way before me, and I continue to ride on the shoulders of those who have gone before us in the space of natural resource management, and I continue to stand proud and advocate and voice on behalf of those who are displaced, those who are marginalized, and our indigenous communities here in Fiji. I have been asked by the team with ABS at SPREP this afternoon to speak a little bit around the engagement of women in decision making and with respect to how best we can involve them when it comes to the implementation. I acknowledge Professor Daniel Robinson as well as Dr. Ivana Wright and OFFA for opening up the talk around some of the challenges that have already been faced in the region with this new concept of implementing ABS and FPIC moving forward. I'm speaking in the lenses of an Itoke woman, a community practitioner, one who has had the best of both worlds, having served in government, as well as within the NGO sector, and also at this particular point sitting and having a neutral bird's eye view into different processes with respect to the implementation of a wide number of our policies and implementation to our community members. The ABS policy, as Offa has mentioned and Rahul has mentioned as well, the national draft Fiji ABS policy has been a joint work through the Ministry of Environment and Waterways, as well as the Ministry of Itoke Affairs, and FLAMA has been the convening partner where we have brought community leaders and community practitioners together, as well as our donor partners back in 2018, and that process has been moving forward ever since. Now, this process has been a very sensitive one, as you can all imagine, and as you can all also have been sharing as well, as of most recently since 2018. And I must agree very much with what Offa had mentioned around it being a new protocol. So imagining the Nagoya Protocol being a new instrument to those that are working within the government corridors and those that are working within the CSO spaces, then try imagining taking down Nagoya Protocol in Itoke language to the fishermen and farmers living within our villages as well. So I mention it as being a very sensitive one, as it is across many Pacific Island countries and here in Fiji. Our governance levels range from constitution to our customary law. And the Fiji National Draft ABS policy reflects this very well. As it is across many of the work around natural resources, we have to reflect and recognize these different spaces between our constitution and customary law as well. So in saying that, where do our coastal communities, where do our traditional knowledge holders and our resource owners stand in this whole process? Now, in thinking through this very, very carefully, and also having do some research and read up on it, and part of the experience that I've had as well, I'm sure you would all agree with me that our people across the region have ownership of the knowledge, the values, the beliefs, together with our practices and our skills. We have ownership of that. We own that. And it has no monetary value attached to it whatsoever. But the big argument that keeps coming into our spaces is who exactly has the ownership of our resources, which is why it is very critical and very key in recognizing those spaces between our constitution together with the different legislations and recognizing that there is customary and traditional law as well. Segueing into the inclusivity and the participation of women in the process of FPIC, in the process of consultation, is a very key one. I'm sure all of you have had some phase of having been involved with community work to notice that the women's group is the one that is often not heard. The women's group is the one that is often not consulted. But they are one of the most important groups in any village or in any community, as you probably all know. But I also strongly feel that as practitioners, as local practitioners and indigenous, sometimes we are marred by the Western knowledge and the Western education that we have been exposed to as well. I would like to strongly suggest or strongly put to the table that different countries are at different components with respect to the implementation of the ABS policies in their countries. When it comes to engaging our women in these Talanoa sessions within these different spaces, there are a few things that we need to consider, and it will be different. I must apologize. It will be different across our Pacific Island countries. One, you need to understand the social relationship of women in that particular village. Some of our villages across our Pacific Island countries, some of them are traditional leaders. They are clan leaders, they are tribal leaders, they are Vanua or Whenua leaders as well. Some of our communities also have very strong women cooperatives. They have small businesses with women who are actually running it. We need to understand what role do they play. Is it a fishing community? Is it a farming community? Is it a farming community where women are part of the sugarcane group or sugarcane group of people that are going out to the sugarcane farms? Respecting that and also trying to understand the kinship and the relationship of our women in a family. For an Itoke family especially, you cannot have the father-in-law and the daughter-in-law sitting at the same table, or you cannot have them in the same room. So how can you expect them to be voicing their opinions in a village hall when you need to be going in to do your consultation for ABS? These are very critical kinship relationships that we need to understand. Number 3, we also recognize that women marry out of their villages. And when they move to the husband's family respectively. They not only take on a name, they take on a family, they take on the responsibilities of the clan, of the tribe, and of the Vanua as well. And they take with them to their adopted villages the knowledge, the skills, the practices that they also have, and it also goes to strengthen the base of where it is that they have been adopted or married into. These are some of the very key things as practitioners or as CSOs or NGOs we need to go in. We also need to build the trust and interconnectedness as well within the groups in our local communities as well. When you say the word FPIC, you're going to get a lot of questions. You need to know how to translate that into their language, into their dialect also. We need to engage the women at a time that is convenient for them. There have been numerous consultations and workshops that we have been a part of that the women are not present in the hall. One, we don't take into account that the women are cooking. They are cooking for the boarding school. They are cooking for the schools within their villages. We need to take the time out and go to them wherever they are. There have been times where we have had to do consultations in the kitchens where they are cooking. If it needs to be done, then it needs to be done that way. There was a time where I had to go out with them too when they were doing their mud crab fishing early in the morning and staying the 4 or 5 hours that they were in the river to see and spend the time with them, but also learn how it is that they go about their livelihood every day. You need to take yourself to them as practitioners and as implementers if you really need to get them on board with the process that we are trying to carry out. But in saying this, Of course, there's going to be conflicts. Of course, there is going to be a lot of a lot of conflicts around who should be approached, who should be recognized, who should be acknowledged. But we must always ensure that we respect the ownership from the community or at the level that you are approaching. I also wanted to just add here that it is very key that we empower and recognize the traditional leaders that are holding the helm of governance and ownership at any community level as well. And for them to also recognize the role of women in the FPIC process. Just a little bit around the barriers, I guess, and some of the challenges. One, it's ensuring documentation and agreements are kept sound and are safe for safekeeping, especially we are still moving from the writing era to the typing and electronic era. We still have a lot of our records kept in our archives and within our different ministries that are still in written form. This is one of the reasons why. When it comes to leadership within any of our communities here in the Pacific, a lot of the genealogy is written down. We need to ensure that we recognize the traditional leaders that have signed in 2021 are going to be the same line of genealogy of leadership will also be recognized 20, 30 years down the line. This is where a lot of our conflicts arise as well. And we need to respect that this will have to take time. We cannot go into a village today and expect the Mbose Vanua, which is the highest body of any Vanua that gives the decision making, to sit tomorrow and make that decision tomorrow. We have to allow time in our implementation policies, in our implementation phases, to recognize this component. That is very, very key. Also, just for us implementing the principles and the values of our respective ABS policies as well. It needs to be carried out with respect by local practitioners who are based in country, who know the sensitivity of the issues already on the ground, and who can also talk through from our traditional leaders to the different groups that are within our different villages. And the inclusivity is one that I cannot keep saying over and over again. I think my last one too that I wanted to acknowledge for our communities here in the Pacific, it's acknowledging that apart from the Vanua, the church also plays a very big part in the lives of our people. So acknowledging that is also an institution that we need to be aware of, that we need to recognize with respect to taking the FPIC process, pre-implementation, post-implementation, whether you're harvesting this today, you're taking back the results today, it is very key that we keep these two institutions working together and that they're clearly recognized. I think I should end there, even though my notes flip another 3 pages, but I thank you for your patience and your willingness to hear us out this beautiful afternoon. Vinaka Rahul.
Thank you, Margaret. I think your experience and your involvement with community speaks a lot, especially your knowledge about some very practical issues that happens on the ground. Several times when we do consultations, we ignore these very basic things, and then it leads up to a lot of confusions and conflicts and disagreements. But that just shows how important it is to speak about these issues and get these issues to be resolved so that we have a very successful implementation of the Nagoya Protocol in the Pacific. Margaret, for sure, we will come back to you as well, because there's several things that you have raised, and it's very interesting to discuss in the spirit of trying to be within time. We'll come back to you and talk about some of those issues a little while later. For our participants, please keep your questions ready. After our last speaker, then we will open the floor and take your questions and comments. So we will now go to our last speaker for today, Ms. Eni Tisunga. She is the researcher for Samoa Biodiscovery Center and the manager of environmental and renewable energy team at the Scientific Research Organization of Samoa. Eni leads the environment and renewable energy team at STROS and holds science qualifications from Auckland University in New Zealand. She attained her Bachelor of Science specializing in environmental science, and she has done Master of Environmental Studies from Victoria University in New Zealand. Having grown up in Samoa, Henny understands the significance of managing limited natural resources in a sustainable way, ensuring the availability of natural resources for generations to come. She believes that this can be achieved through careful monitoring and management of natural resources, promoting a circular economy where waste is managed and repurposed, and investigating in renewable energy technologies. Ms. Henny, you have the floor.
Thank you very much, Raul. I'm so curious where you got all of that introductory material from. Thank you very much. That was really kind. And Talafalava, everyone from Samoa. It's truly a privilege to have this opportunity to share with you all just a bit of my experience so far as a researcher or a bioprospector and how our work relates to ABS themes. So the bulk of my talk will be on how we have gone about accessing genetic material for research. But we'll first just briefly touch on the context of our research work, or the context of bioprospecting and its growth in Samoa. So as Rahul mentioned, I'm a researcher for the Scientific Research Organization of Samoa, or SROS, and we're a publicly funded research organization comprised of a growing number of Samoan scientists. And the bioprospecting work is a newer arm of research under SROS, under our Biodiscovery Center, that was recently established in 2018 with a strong support from our government and our people for two main reasons. Firstly, there is a growing belief in the potential of our bioresources to aid our pressing health concerns. And secondly, we believe that the strong support from our government has also come about after some lessons learned from past examples of bioprospecting that has been carried out by mainly overseas or external researchers. So there is a strong sense of wanting to protect our bioresources from being exploited for research. And there is that idea that by having the bulk of bioprospecting work carried out by our local scientists, we feel that this may better protect our genetic material and perhaps better guarantee that any potential benefits from our research will all come back to Samoa. So this kind of, I guess, thinking really highlights the importance of ABS and why there is a need for the adequate policies or framework to be in place to kind of help alleviate, I guess, this fear of research being done, or especially external researchers, which maybe in the future could potentially help our communities or Samoa. So our bioprospecting work at the moment, we're focusing on screening as many plant materials as possible for bioactivity against three main areas of health concern, which is anti-cancer research, antimicrobial research, and anti-diabetes potential. And we've found that preliminary results have been quite positive. It has indicated the high potential for Samoan bioresources to contain bioactive compounds that may be unique in the field of medicinal development. So this is ongoing research where we're working to identify and purify certain bioactive compounds in the hopes of developing some sort of medicine that will be beneficial to Samoa and the region as well. So how have we gone about accessing genetic material? Just wanted to highlight a few main lessons that we learned. Although we've only been doing it for a few years now, some main lessons have been highlighted in our bioprospecting journey so far. Firstly, accessing plant material is definitely made easier by approaching communities that you already have a pre-existing relationship with. So we have done this by approaching communities of which our research team already knows well. So for example, our own families, our own villages, we have chosen to approach them because of this pre-existing relationship. There's a pre-existing trust, so it's easier for us to discuss why we are needing to access genetic materials for research. And they're more open to listening to, I guess, our research and ask questions and so forth. So that has definitely been our experience. And our second main area of accessing genetic material is through our forests that are under government reserves, because accessing these certain areas permission is sought from relevant government agencies as opposed to communities. So I think as researchers, we always have a small fear of an unrealistic expectation from communities that we approach, which is, we understand their expectations, but in this field of biomedicinal research, I guess we don't want to give false hope. For biomedicinal research, it can take many years before a product is even produced, if any. So we do have a small fear as researchers going into communities, which is why our approach has been developed, as I mentioned before, entering communities where we already have a relationship, or entering reserves where we're able to get permission from relevant government agencies. And I think my last few comments, I just want to briefly comment on traditional knowledge, or TK in Samoa, and why our research team have chosen not to integrate TK into our bioprospecting work yet. So traditional medicinal remedies are still widely used in Samoa today, and our traditional healers that hold this knowledge are often very careful with whom they speak to regarding the methods they use, how they prepare and apply their remedies made from our local plants. And this is something that us researchers at SROS, we acknowledge the importance of medicinal TK for our families and communities that continue to practice it. And so we do not seek to ask healers at any time to share their treasured knowledge, as we understand that it is kept within families and passed down through generations. So at the moment, our bioprospecting work has been purely scientific. As I mentioned, we try to identify bioactive compounds in our flora and sometimes marine samples as well, to identify bioactive compounds in the hopes of developing medicinal drugs to help our people. So that's just a bit from me, but thank you very much, ABS team, for this opportunity, and I'm happy to answer any questions. Sign out.
Thank you, Annie. I think you've provided some very interesting information as well, especially to do with bioprospecting, and some of the things that we'll probably discuss, which will be consistently being asked, the question of the issue of trust in the whole process of access and benefit sharing. Now what we will do is we will go and have question and answer sessions. But before we open up the question and answer session for the participants, I will probably give a few minutes extra to all our speakers, just to, in case they would like to make some comments or some other responses. And I will begin with Professor Daniel Robinson. I have one question with you. One particular issue that you mentioned was about biotrade, and something which is quite common in the Pacific is the trade of coconut oil, or whether it's tamanu oil or dealer oil. Also, these things which are traded as commodity, I wonder if these resources are taken out of a country on a trade deal, and then there are some research being done. How do we go about dealing with such a situation where something has been traded as a commodity, but ends up getting, being researched on? And also, if, say, for example, argan oil is quite known in ABS studies, if oil is being traded as a cosmetic product, I mean, do we need to have an ABS agreement for that? Because we keep saying ABS is all about bioprospecting, about commercialization, biodiscovery. So if something is being traded as a product, and not necessarily there has been any research on biodiscovery stuff being done, how do we deal with such a situation? Thank you.
Thanks, Rahul. These are really good questions, and we hear these sort of questions a lot. So the first one about some of the oils in the Pacific, whether it's coconut or tamanu and other things, when they leave the country. Yeah, so this happens all the time, and we know it's happened with kava too. So these resources do leave the country, sometimes whole plants. So kava plants might be traded, either with a permit from the Department of Agriculture or without one, it might be illegally. Yes, there would be cases of that where researchers have then done the research in other countries without having gone through the proper processes. And I guess the good thing about the Nagoya Protocol is that it has user measures and compliance measures. So around the world, we're seeing many countries ratify the Nagoya Protocol now. I'm not sure the exact number, the total, it's sort of above 130 countries now. So we're getting many, many countries in the world have ratified. So if you take Europe, for example, Europe, if they were European researchers, Europe has access and benefit sharing regulations. The European Union put them in place, and then countries then have to develop their own domestic laws. So if the researchers were in Germany or in France, or even the UK, which has also ratified the Nagoya Protocol, the researchers in those companies have to comply with not only their domestic laws on access and benefit sharing, also the laws of the other countries that they interact with that have access and benefit sharing legislation. I know, for example, if we take Palau or Samoa or Vanuatu or other countries that have the research permit and access and benefit sharing requirements in place under the Nagoya Protocol, the researchers in Europe, in France or UK or wherever, they have to comply with the countries that they're trading with, really, if they're doing research on the biological resources from those countries. So often the university researchers and the companies, if they haven't complied, they can be punished under the domestic laws in those countries. And some of the penalties are very serious. So if you look at the Swiss law, the penalties are something like 100,000 Swiss francs, which is close to 100,000 US dollars. And there can be serious penalties as well, I think criminal penalties for not complying. And so that's why I think the Nagoya Protocol as an international regime has significant strength. We also have the clearinghouse mechanism where we should be able to check certificates of compliance to see whether permission was given by those countries, so Vanuatu, Samoa, etc., to do research on those resources. So there is an international way of tracking these things. It will take time to set up that system. And as Offa was talking about, we need the Pacific countries to add details of their national reports and their certificates of compliance. Where they issued permits, those certificates of compliance should go in the clearinghouse so we can check. And people like myself and Ivana and many other researchers who work in this space, the SPREP team could then check with the clearinghouse and say, oh, we know there's researchers looking at Te Manu, but they don't seem to have got permission from the Pacific countries. We should contact them, or even contact the governments in their home countries, and they might need to be warned or penalized under their laws in those countries. And then I guess the second part of your question, Rahul, was about argan oil, which is trading in bulk quantities of oil for cosmetics. And yes, it just depends. If they're just trading in oil, a lot of the trade being done is being done fair trade. And there's not much research being done on oil. It's a tricky one because some of the cosmetic companies are probably doing research for formulation of new cosmetics. If they're just adding the oil to a cream and there's no real research being done, then I guess we can't say that it's access and benefit sharing. But some high-tech stuff is going on. So companies like L'Oreal were developing new extracts from argan. That's definitely considered research. And so they set up, they were getting biochemical extracts, so flavonoids and proteins from the argan tree. That's definitely R&D, and so they set up a benefit sharing agreement with some of the women's cooperatives in Morocco. So there is a line, and I think companies often do know there is a line that they've crossed in doing research, and I think it's also up to others to point out that they've crossed that line from trade to the research. Thanks.
Thanks, Dr. Daniel. I think you've given a good summary of that information that I had requested. Participants, if you have questions, you can also raise your virtual hand or put it in the comment box and we'll take your questions now. But while we are waiting for questions, Maggie, Margaret will come back to you just on a very interesting point that you had mentioned about the barriers in communication and involvement of women, language, complicated issues, village level involvement, right timing. You've raised a number of issues on how we can engage women in decision-making process. What I would like to hear a little bit more is, you've mentioned a whole list of problems, but do you see, or are you able to give some options on what are the things that we can probably do to improve this conflict, or we can improve this situation? What are your views and what are your opinion on how we can deal about this situation we have? Thanks.
Thank you, Rahul. I think Flemma has come through the last 20 years of having learned a lot of lessons learned, as well as a lot of best practices, especially when it comes to consultations and engaging with our communities. Because we're talking around the FPIC process with respect to access benefits, also cuts across all types of consultations that we have been involved in, whether it's been whether you've been in the CSO space or whether we've been in government. And I think a lot of the times we keep saying that we should do consultations, which is so easy to say. But I think the onus and the responsibility is for those who are indigenous and those who are in this space to make the difference, to always do your homework. I think is one. We must always allow ourselves to do the proper scoping that we need to with respect to the different villages. You need to understand, like I had mentioned, the traditional leadership and governance within the villages or within those communities. Is there a Vanua leader in place? If there is, then how will that help us? If there isn't, how will that work against us? We need to understand what is the status of natural resource management and use within that particular community. Is it one that has been involved in traditional conservation? Is it one that has been working close with the CSO? These can help influence, and I think Annie had mentioned it as well. We have a lot of our traditional partners and traditional leaders, and the relationship that we've had with different villages across Fiji and the bigger LMMA network in the LMMA countries as well. But also it's knowing the language. You have to take the time to understand the language. You have to understand the dialect, and how best will these communities receive it. We keep talking, like I said, about ownership. We need to acknowledge that this is their space. This is what they turn to at the end of every day to draw on for their livelihoods, whether it's from the sea or whether it's from the land. We're not going in there with big size textbooks and very colorful posters, but we need to create the atmosphere where they are brought into that space. And it also comes with knowing how to facilitate. These are, it sounds like it's very simple, very basic, but it will need to be done in order to take the big articles and the big language that is in the Nagoya Protocol and that we're putting in our policies down to the fisherman and the farmer and the traditional leader and the women's rep and the youth rep, if we need to roll out the ABS process in country. I hope that answered your question somewhat, Rahul.
Yes, very much so. Thank you, Margaret. I got some questions in the comment box as well, and those presenters can also read these questions as we go through. Again, our participants, if you'd like to ask a question, you can raise your virtual hand. We will give you the floor to ask questions, or if you want me to read your questions, you can put it on the comment box. I have one question from Ali Ferretti in Fiji. He is a consultant and he has done some ABS work for Fiji. Let me see where his question. Sorry. Okay, so his question is a question to all the panelists. What should government's role be in ABS contract negotiations? So any of our speakers can take the floor to respond, or your personal opinion on what should government's role be in an ABS contract negotiations. Ofa, you wanna speak first? Probably you've been working with governments on ABS stuff.
Thank you, Rahul. I think government can play a very critical role in terms of negotiating ABS. From experience in the countries of the Pacific, there's already been some biopiracy cases where the negotiation is done straight with the communities without the engagement of the government. Just bear in mind, the government is recognized as the legal entity of the country. Communities may not have that as a legal entity. So the role of government will be, they are recognized as a legal entity. So when it comes to dispute, they can act on behalf of the country or the community itself. I think that's, apart from that role, government required to designate national focal points, checkpoints. They are the ones that will do the close monitoring of how your traditional knowledge or how your genetic resources have been utilized outside of your country or within your country. So I think for this question is that the government, we will advise the government comes in and be involved right from the starting of the negotiation. They can also be a party to the contract itself. As I mentioned, because they are the legal entity of any country, so they can take the matter forward if there is a dispute arising from that particular contract.
Thanks, Ofa. And I also think that the government's main role would be also that you look at the whole access and benefit sharing. If the government does not bring in a domestic policy or legislation or framework, then it's a free access. So basically, there's no guidance on how your country's natural resources would be accessed, because every country has sovereignty to decide how they want it. If they don't have a rule, if they don't have a procedure, that means it's free. So I think that's something that we as a global community need to understand, that so long as there is a policy, we will follow. If there's none, then we won't follow. There's nothing to follow. So the major role of government is to take this international commitment and domesticate it through a policy, through a framework, through a legislation. That's one of the key roles in the ABS. That's my opinion as well. Is there anyone else who would like to add something from our panelists?
I was just having a look at Vanuatu has a flowchart, Rahul, that they use for the permit process and for checking. So there's a number of steps in their process, and I think it's similar in Solomon Islands actually. That when you apply for a permit, you're allowed to come and meet with the community to negotiate the access and benefit sharing agreement where you're going to do the bio discovery, and then the government. So they allow you in a preliminary process. You're allowed in to come and meet the community, and then the government then checks the access and benefit sharing agreement before signing off on the final permit to allow the bio discovery activity. So there's certainly a couple of stages in the process, and the government's involved in allowing permission and then checking the access and benefit sharing permit has been made with the appropriate community authorities.
Thank you, Dr. Daniel. There's a question from Dr. Justin Rose, and he's a lecturer at University of the South Pacific. And his question is, drawing on FSM experience, a key issue in developing policies and laws to implement the Nagoya Protocol is anticipating and accounting for ownership disputes. Just as there are land disputes, we can expect disputes about ownership of genetic resources and related traditional knowledge, especially when the prospect of money arises. The 2018 Palauan Act does not seem to address this element. Has this been encountered elsewhere, and has it been accounted within the regulatory frameworks? An open question to all our panel members. Anyone can respond.
I think I can respond to that. Having been involved in the drafting of the Palau Act, the details is in the regulations itself, Dr. Justin Rose. Unfortunately, the regulation is still in draft and awaiting discussion at the parliamentary level in Palau. But for the act itself, it didn't really detail how the benefit sharing will be distributed. But just when we had the consultation as part of the regulations, that one of the things that came clear from the participants, both from the communities and the government, is that there are certain, I think there is, the ownership itself is that from the coast to, I think, 12 nautical miles, that belongs, those resources belong to the communities, and beyond that belongs to the government itself, it's state owned. So in terms of benefit sharing, when it comes to something that it is found within the 12 nautical miles or beyond the 12 nautical miles, is that they have a calculation for that, which is in the regulations. I think it's about 30, 70, if it's the resources that is found beyond the 12 nautical miles. But what I can do is that maybe the team can probably contact our counterparts in Palau, and if they would like to share the regulations with you, it has the details of what would they want, how the benefits, especially in royalties, will be going to be distributed between resources that are state-owned and resources that are community-owned. I think that's my answer to your question, Dr. Justin Rose.
Thank you, Ofa. Any other panel member want to respond? No? Okay. I think it's a very interesting question as well, and a question that I'd probably, if we had one of the legal experts from Fiji as well, we could have asked, what does the constitution and the country's law state in terms of you can own the land, but you may not own the natural resources on the land. So you can give access to natural resources, but you don't have access to it because legally you are not entitled to. I think that kind of situation is something that is very difficult to deal with, unlike Palau, which is still, as Ofa mentioned, still in the process of developing their legislation, and probably through a regulation, a lot of clarity will come. We have what?
Sorry, Rahul, I just wanted to add, I'm just looking at the law itself, and section 5014 has got the benefit sharing between national and state governments. But as I mentioned, it's got the detailed percentage of how the fees, profits, and royalties will be split between state and national governments. National government having representing the communities itself when it comes to ownership of resources. But in the regulation itself, like I mentioned, maybe Rahul and the team can probably ask for permission to access the regulations, and maybe can be shared to Dr. Justin Rose, as I know that he's done a lot of work in FSM that may have the same kind of situation with Palau in terms of the government structures that they have in the Northern Pacific. Thank you.
Sure, thank you, Ofa. We have a question for Annie from Vanuatu. What are the challenges faced by research institutions with the government policies and legal requirements relating to bioprospecting? Basically talking about challenges on government policies and legal requirements to bioprospecting. So what are some of the things that you'd probably face in Samoa, or even Daniel and Ivana are also welcome to add.
Thank you, Rahul, and thank you for the question. I think so far we've been really fortunate in that I think in Samoa, the policies or regulations that researchers have to follow are different if you are a local researcher or if you are overseas or outside a researcher. So for our research team specifically, we do work closely with Ministry of Natural Resource and Environment, who are the focal point in implementing ABS here in Samoa. And so we just have to let them be aware of where we are wanting to collect samples from. But in terms of real challenges, I think the only challenges I mentioned are the ones that I mentioned in my presentation, is discussions with communities that we approach. In terms of regulations from our MNRE, there's not so much. So it's more like being able to openly communicate with communities that we approach to extract genetic resource. And as I mentioned, being a local research organization and being viewed as a local is definitely beneficial to our research, and that we're usually welcomed most of the time without any issues. They're usually open to discussing us, divulging the reasons why we need the genetic resources, and then being free to ask questions and so forth. So yeah, there's always, as I mentioned, a fear of unrealistic expectations and rewards. But all in all, I think because we've only focused, as I mentioned, sampling from communities we already have a pre-established relationship with, and sampling from government reserves, we haven't really had that much of a challenge. But I'm sure researchers in other parts of the regions might have different experiences or different challenges, but that's just from us. I also have to highlight that our bioprospecting work is relatively new. We just started in the past few years, as I mentioned. I think going forward, as we want to approach more communities that we haven't approached before, we might definitely encounter different types of challenges.
Thanks, Annie. I think I also noted the same point about the trust issue and expectations from communities to fulfill certain things that is expected of the bioprospectors. Sometimes there's upfront requirements of payment and something like this, and whether the research itself, which is going to take maybe 50 years or 10, 20 years, will yield any result or not, and whether the company is ready to put in money for such a research. That's something that we keep hearing and keep talking about. I would like to hear something from Dr. Ivana. What is your experience with negotiating a contract, working with communities in terms of expectations and trust issues?
I think in terms of, thanks Rahul, in terms of working with communities and trust, I think that from coming from more of an outsider perspective, when you're moving into a community where you're not a local, it's a matter of time. And I'm always concerned that particularly people coming in to do research aren't taking the time to spend with communities to explain what it is that they're actually looking to do, to provide the information, to build the relationships. There's always constraints on funding. People sort of seem to rush that discussion and negotiation process, and that can either result in the community pushing back entirely and just blocking access even at a discussion level, which is absolutely the community's right. But then, it runs the risk of not building, long-term relationships for the benefit of both parties involved. So my biggest personal concern in those kinds of negotiations is the pressure of time and lack of funding. Then I think, as Margaret spoke very eloquently about before, is doing the homework. So knowing who to speak to when you're negotiating, what the structures, what the frameworks are for that particular community, and that will differ within a country, within a region. So from my perspective, going into communities, having done that pre-work is absolutely critical before starting negotiations. You've got to know that you're talking to the right people and that you're going through the right processes before even getting down to the legal terms itself.
Yeah, thank you, Dr. Ivana. I have a similar question from Mr. Anil Joshi, who's from India, and he's asking a question. I think it's more targeted to Annie, but I'm sure Daniel and Ivana, you can also take this question if you like. Is there any mutually agreed terms arrangement between a user company and a provider community in Samoa? So Annie, this is for your existing research that you're doing. Is there any such agreements? And if there is a bipartite or tripartite, like here in India, sometimes it can be between the Samoa Scientific Research Organization and the community, or is it three-cornered, your research organization, the government, and the community. Something I think that is an experience that they have in India. And Mr. Joshi, you are welcome to make comments if you would like to. You can take the floor. But I will give it back to the speakers just to respond, maybe Annie, and then Ivana and Daniel, if you'd like to add any comments to that.
I think honestly, from the samples that we've collected so far, we do not have a formal MET arrangement. It's more like informal discussions and agreements with the communities that we've approached, which is usually our own home village communities, as well as permits from relevant government agencies. In terms of MET with our communities, no, we have not. I think this is also mostly due to the early progress of our research. I think it's something that we definitely want to develop as we further into the research. For example, as we identify bioactive compounds, we are aware of exactly where we sampled from. If we do identify bioactive compounds and purify it, and I guess progress to potentially products and so forth, we have all of the data of where exactly we took it from and so forth. So I think that's a downfall on our part. We don't have any official MET agreements so far. I think the only legal document that I do know that I'm not sure if it's still in draft form is between STROS and our government and some overseas labs that we are collaborating with who are assisting us in progressing our research, because we're a little bit limited in terms of equipment at the moment locally. So we do have had to reach out and form collaborations with some laboratories in New Zealand. And so we have in draft legal documents, I believe, led by our Attorney General's office to protect the genetic material if we do need to take it over to overseas labs to analyze further, or to confirm some of the things that we have already started locally. That's the only documentation or legal document that we have so far, but in terms of with our community, no, we have no formal MET arrangement yet. Thank you.
Thank you. Any further comments from our speakers on the same question? Daniel?
Daniel, do you want to talk about the Mamala arrangements or?
Sure. I mean, yeah, there is, yeah, obviously the Mamala case is old. It's pre-CBD actually. So I don't know that you can call it, it's not exactly MAT as under the Nagoya Protocol, but there are some agreements in place between the AIDS Research Alliance and the government of Samoa, and also the University of California, Berkeley. And they're from the 90s, so and 2000s, so they're quite old. But they, Paul Cox, the researcher, has written about them. There's a number of papers. There's quite a bit of information about those. More recently, throughout the Pacific, I don't know specifically for Samoa what permits they've issued, but throughout the Pacific, we've commented on permits for a lot of academic research, particularly. So people taking samples in countries and doing field studies and those sorts of things, ecological studies. And so they've been able to obtain permits, and they've signed agreements, which are often quite short agreements, which are, I guess, like they are, Matt, really, where they have to share data and they have to share reports and non-monetary benefits, basically, share samples with the government departments relevant. So there are plenty of examples of academic research that the governments may or may not be able to tell you about. Sometimes they're secret because of the arrangements in place. But there's not a lot of commercial ones. There have been a lot of applications in the region, and then some of those applications have been rejected, or they've sort of sat there for a long time, or there's been concern about aspects of them and they haven't been finalized. So there may be some commercial ones, but a lot of the stuff that I've seen have been just academic permissions and agreements.
And I'd add to that from my understanding of the Indian regime, we reference the sort of bipartite, tripartite arrangements. The Indian regime is much more structured in terms of how the state biodiversity boards and the biodiversity management committees work within the National Biodiversity Framework. So I think perhaps there's quite a big difference between that system and what you're seeing in Samoa. I think that was the question from Anil. Yeah.
Thanks, Dr. Ivana. There's another question for you, Dr. Ivana, with regards to Samoa as well from Ntole. She's talking about when the product does not reach commercialization. I think in your opening remark, you mentioned, when the product does not reach commercialization, are communities open in discussing the issue or are limited as they will be expecting something that they will not receive? What happens in such a situation? Thank you.
Yeah, thank you. Thanks for the question. This is one of those ones where setting out up front and having those discussions around what would work for the best for the community is really important. And this is a capacity building issue, I think, because quite often community will be approached with an offer of these are the benefits and joint, and they may have an idea that owning intellectual property rights is a good option. I think communities are open to a range of benefits, but it's more having an understanding of what to ask for and what works best for that particular community. Not so much that the communities are limited in any way. Once the agreement is in place, of course, then that becomes more challenging if the community then becomes aware that this isn't progressing and what they want to do with it. But unfortunately, we have seen in some examples in Australia, joint ownership of intellectual property, and then where that's not progressed, the patent term is due to expire in, I think, 3 years. And given the timeframes in clinical trials and progressing a product, it's going to have consequences for the community. So I think it's raising awareness within communities who are negotiating to make sure that they understand that there are options and to perhaps spread the risk in some ways.
Thank you. There is a question that I have from UNEP, and it is across to all the panel members. Anyone can take this question. Ownership of traditional knowledge by particular individuals or communities may bring challenges to the effort of regulatory approach to the implementation of Nagoya Protocol. Any good lesson learned or experiences so far? It's on your chat box by Sanjin Lee, so you can have a look if any panelists would like to respond to that.
I've talked about it so many times, but sorry if you've heard it before, but there's lots of examples. The one in the Cook Islands to do with SimTech is one sort of example where the researcher Graham Matheson he's a Cook Island Maori man. He was from the Cook Islands from birth. He had an arrangement he set up an agreement with the Kootenui. So the constitution in Cook Island has the House of Ariki and the House of Kootenui as paramount chiefs and then sub-district chiefs. So he had an agreement with the Indigenous representative group in the Cook Islands. That was for access and use of traditional medicine for bone healing, which is known, I think, throughout the Cook Islands. So that's one example. There's other examples, like in Vanuatu, there's an agreement. The New York Botanic Gardens has an agreement to share non-monetary benefits for doing ethnobotanical type work. So they have to share books and those sorts of things with communities. And so they work more closely with very specific communities in Tanna and Anatium in the Southern Islands. And so they are supposed to share benefits with those particular communities, including educational materials in local languages. So yeah, there are different examples in different circumstances. Obviously, yeah, you're right, and Margaret spoke about it really well, that there's different communities that are knowledge holders. Sometimes there's traditional healers networks Sometimes a specific medicine is passed down a family line, and that family is the family that gives permission for that medicine. So it's really important to get to the right people to speak for that particular medicine or biological resource.
Thanks, Daniel. There's a question from Vanuatu. I think Donna's asking, has there been any member country in the region that has already developed its ABS contract or are in the process of developing it? If so, what are the challenges encountered so far? I think targeted to, directed to Ofa rather. Ofa, would you like to mention? But if you want, I can also just say that so far from SPREP's point, we haven't really seen any ABS contract really actually happening, but there are processes that are put in place and discussions happening. Say, for example, Palau can give an example of what kind of a layout or a template they have for the contract, but the actual issue is of contract negotiation, which is at different levels in different countries. Ofa, I'll come back to you. Would you like to add something and say a few things about this question?
Thank you, Rahul. I think that Daniel will probably have a more fair idea of the ABS agreement that Cook Islands has with Simtech. Is that I think in the course of implementation of the Nagoya Protocol, we came past something like an agreement between Simtech and Cook Islands. But having said that, one of the there's a part of the question on challenges of negotiating ABS contract from the Pacific. I think negotiating an ABS contract is very challenging, especially when the concept of who owns the resources, the ownership of resources, is not settled. So that is one of the first few things that you need to, probably as a researcher, will have to know the traditional knowledge or the genetic resources, who has the legal ownership of those resources. And that's quite challenging across the countries of the Pacific because, in terms of transboundary resources and transboundary knowledge, it's very common in the Pacific. So 2 or 3 communities can claim that they own that kind of ownership or that resources or the traditional knowledge. So that is a challenge, is that when it comes to transboundary, a lot of the knowledge and a lot of the resources in transboundary from community to community. And so a challenge is that the identification of who owns the resources, so you can go to that particular individual or community and speak to. One of the things too is capacity to interpret ABS agreement. And that's where government will have to come in and provide that sort of support through their AG's office or the Solicitor General's office, interpreting the legal agreements and ABS agreement. And I know that ABS in the countries, in terms of implementation, is we need support and we need the capacity to actually negotiate the contract. I think that's what I can say, but probably I can pass it on to Daniel Robinson. He has mentioned the Mamala case, which was an agreement which was dated way back before pre-CPD. But there's also the agreement which was forged through the Simtech with Cook Islands. So maybe Daniel Robinson can probably provide some ideas on the challenges with negotiating that particular ABS agreement in Cook Islands.
Thanks, Ofa. Yeah, I mean, I think it took them quite a while to negotiate that, and they had a lot of legal advice. So an Australian law firm helped them draft that agreement, and it was chaired at the meeting of the Kotonui before being finalised and agreed. So it's a very long legal contract, the Simtech one with the Kotonui. It's got a lot of the provisions and clauses that Ivana and I were kind of mentioning about intellectual property. So there's joint intellectual property for the Simtech situation. The Kotonui are actually mentioned on the patents. There is benefit sharing. and the patents are allowed under that situation. There is benefit sharing in relation to the cosmetics. There is also, it allows Dr. Matheson or the company Simtech to continue to do research to try to turn the bone healing traditional medicine, to reformulate it, to develop something from it, to create a pharmaceutical. And I know that it's been sort of reformulated through that process. I don't know if it's exclusive. I can't remember. I saw the agreement years ago, and I can't remember all the details. So I know about most of it from talking to Dr. Matheson and the Co-Tenure. There are other countries that I know have started trying to develop mutually agreed terms templates, and I think that's not a bad idea. The ABS initiative has a template sort of tool that you can use through their website. There's the Swiss government has an ABS mutually agreed terms tool as well. I think the Australian government has a template agreement. I know the Northern Territory government in Australia has a template deed. So there's a few floating around now that might be useful. Probably more useful than the Mamala agreement because it's quite old. It's very short. It doesn't have provisions on duration. It doesn't have very good provisions on dispute settlement. It's not a very watertight sort of agreement. It's sort of more like an MOU. I know a lot of people use the language MOU, but that's not not usually a strong legally binding contract. Whereas with access and benefit sharing, if we're talking about long-term benefits that might be in the tens to hundreds of thousands of dollars in some cases, we want it to be a more airtight legal agreement if possible. So a clearer, transparent agreement that has dispute settlement and those sorts of provisions in it, and the jurisdiction where disputes can be resolved. And that might be in the Pacific country, or it might be in the United States or in Japan or wherever the researchers are from. And that's up to the parties to negotiate that. It is hard to develop templates agreements because all the circumstances are different. So the countries have different legal systems. They have different expectations. Communities will have different expectations. We're also talking about very different types of research, from food, agriculture, forest type research, biodiversity research. Sometimes it's cosmetics, industrial enzymes, pharmaceuticals. They're all really different industries, different purposes. And so I think that's why it's hard to do the template agreements. I've worked a little bit with some countries on starting them, and we haven't really finalized any. So I think it's something that we could still support countries to work towards. And I don't want to dob SPREP in here, but we could definitely try and work very closely with SPREP and Ivana and some of our other legal experts to help develop mutually agreed term contracts, templates. And I think that would be useful definitely for the Pacific countries. Like I said, it's challenging because every case is very different, really. So that's a big challenge going forward.
Thanks, Daniel. I think there's one more question from Papua New Guinea, and I think it's an interesting one. Again, I'll open this question to all the members of the panel. It is about land tenure, which is a system, maybe big challenge in the process when it comes to ownership of genetic resources and traditional knowledge. In instances where women are not owners of land, where the genetic resources are found but are holders of TK associated with the JR, how do we effectively address the issue in the prior informed consent process to ensure women are included? Any examples or experiences or success stories can be shared with us? So if there are any, we can talk about that, especially when someone else is the owner of the genetic, the land tenure, and what else? Yeah, where women are not the owners of land, where the genetic resources are found, but are holders of TK. So there are two different people. One is the owner of genetic resources and traditional knowledge, and one is the owner who could probably give the access in this case.
Rahul, can I take a stab at
yes, please go ahead.
responding
yes.
to that? thank you very much for that question from PNG. It's a very valid one, and one that is very, I think it hit home hard for many of us in the Pacific region because of the societal role of women. And I think it goes back a little bit to what I had shared. In order to have women as part of the process of FPIC, we really need to take a step back and see the communities where women have leadership roles is a good point to start from. There are women in our communities and in our villages who have who hold strong leadership roles as well. There are also women that we can be strategic about being the voice. For example, when I talk about women who are in a strategic role in our villages, these are women of the wife of the talatala, the wife of the reverend. You have the wife of the chief, or the wife of the traditional leader. These are champions who already have a standing in the community as well. If they are what do I say? If they are traditional resource owners in that particular village, from where they are born at, it's an even bigger bonus. As I had mentioned as well, we have to recognize that the big majority of the women as well are women that are marrying into a particular village also. So while moving in the space of the women, we also have to acknowledge and do our homework and work with our traditional leaders as well, because the traditional leaders are the ones who will open up that door for our women to also have a place to be heard and consulted as well. So a lot of moving spaces, a lot of moving blocks in that particular space, but it's knowing who is there in the villages, who can be the champions of the voice of the women, and really knowing how to maneuver within those spaces as well, as some of the practical examples I'd like to put to the table this afternoon as well.
Thank you, Maggie. Does anyone want to add any more comments? We don't have much time left, and I think we pretty much had all the questions that came in. If you still have any questions, please, participants, you can keep those questions and email it to us. We can always have an email discussion on your questions. But I would like to thank you all for being part of this webinar. It was great to hear our experts speak on negotiation of access and benefit sharing contracts and agreements. And I would like to thank all of you to participate in this webinar today on behalf of the Director General for SPREP and our Director for the Island Oceans and Ecosystems Division, where we are housed at. I would like to thank you all to participate. And of course, our presenters, Dr. Daniel Robinson, Dr. Ivana Wright, Ofa Kaisami, Annie and Margaret, thank you so much for having accepted this invitation to participate and also to present and share your knowledge with us. I would like to also acknowledge the support of our partners and donors, ABS Initiative, UNEP, JEF funded project, as well as our countries, the national focal points that have shared this flyer for participants to join this webinar, and our other participants from around the region and outside the region as well. Thank you so much for joining us. With that, I would like to thank our team, our biodiversity team at SPREP, our supervisor, Amanda, our team, our colleagues, Juni, Vi, and our friend James, who's been sending you multiple emails to remind you of today's webinar. Thank you all, and we're looking forward to maintain this relationship and collaborations with you all. Thank you so much for your time. Have a good afternoon. Thank you.
Thank you, Rahul.
Thank you, everyone. Take care.
Thank you, Mr. Rahul and team.
Just before we all log off quickly, if you have cameras, can you switch it on so we can take a quick snapshot of the photo? I forgot that. Sorry. If you have your camera, you can switch it on and we can take a quick photo. Sorry, James.
Go ahead. Hey, Rahul, are you able to take a snapshot from your end?
Yeah, I will try. Just give me 1 second. Okay, yes. I will say 3 and then everyone will smile. And if you are not smiling because you don't have your camera on, then you can just put a smiling photo of yours. Oh, we have Isabel there too. All right, 1, 2, 3. Let me see if I got it. Give me 1 second. 1 second, please stay around.
Still turning on their cameras.
Can't see you, Winterly.
Okay, I'll take one more photo, please. Now pretend to smile again. 1, 2, 3. All right, thank you so much. Have a good afternoon. Bye-bye.
Thank you.
Bye. Amanda.
Bye, Bella.
Bye, Bella. Come up for lunch.
Thank you, Thomas.
Hi, Bella.
Thank you. Bye.
Bye,
Robinson.
Thank you, Thomas.
Yeah, thank you. Bye.
Good job.
Thanks, prep team. Thanks, Rahul.
Bye.
Right.
Yeah, Opan. Bye, Amanda.
Bye, Ofa.
Bye. Bye, Rose.
Oh, Rose. Bye, Rose.
Bye, Julie.
Oh, and Dorothy. Hi, Dorothy and Warren. Just everybody.
How do I unmute? Bye. Thank you, Opa. Thank you, Junie.
Bye,
Thank you,
Dorothy.
Rahul. Thanks, everyone.
Bye. Aw, let me see these people. Okay.
Good job, everybody.
Hello.
We're still recording.
Oh.
Yeah.
I love that. Stop recording.